sure that you guys are all pretty excited about this topic. It's actually one that comes up quite a bit, so I'm sure that you guys will appreciate the topic. I assume that you guys can all see what's on my screen, the title page?
Yeah.
Great. Then we'll just move on quickly. I don't know if Chris went through this on his presentation, but basically, you know, you've got the screen that looks basically like this. If you want to make your screen bigger, you can kind of click on it and drag it, make it a little bit bigger. Otherwise, you should see the grab tab, which is up on your right there. It's got some arrows that kind of point to it. The audio pane provides some information. You should probably have that on your setup, so we know it's all good. I'm going to click right through some of this stuff. You've got the audio pin because you can hear me. During the presentation, you'll obviously have the ability to send questions. You can either do them via the questions box, or just, since we're finally connected, you can just shout them out, and I can answer them that way. If you've got a question, you want me to slow down, you can also raise your hand, and I'll know that you guys have a question. Either way works. I'm pretty sure that this presentation will be so comprehensive and well put together, you probably won't have any questions. Laughter. But if you do have questions, you can always just shout them out, and I'll try to answer them as we go along. But obviously today we're here to talk about the Economic Loss Doctrine. Some writers out there, some scholars will tell you it's the most simplest doctrine out there, the most simplest rule of law, while others will tell you it's the most complicated rule of law. I think that there's some truth to both statements. But I mean, the Economic Loss Doctrine applies in so many different areas of subrogation, of litigation in our system, that I think we'd be surprised. For example, I mean, does anyone know who Roy Pearson Jr. is? Does remember anybody that name ring a bell at all?
No.
He is the Washington, D.C. former administrative judge who sued his dry cleaners. Remember the dry cleaners who lost his pair of pants, and he sued them for $67 million. That's a situation that where the Economic Loss Doctrine comes up. Other ones that probably more along the lines of what we'll see are a case I just handled involving a printing company who had contracted with a moving company to move one of these big presses, printing presses, to a new location. After the moving company dropped the printing press, it was basically damaged beyond repair and had to be replaced. And so the printing company was paid by their insurance company, and we pursued a subrogation claim. And we had to pursue claims for not only the replacement of the press, but also for damages because they couldn't use the press, and they had about $250,000 in business interruption losses. So think about that situation as we start discussing what the Economic Loss Doctrine is and how it applies. And then the other one, which is near and dear to us cheeseheads, is a pretty common situation where you have claims made by farmers who have bought a product such as a milk replacement substitute for their herd of cattle. The product fails. The cattle either get sick or they become ill. They either die off, or they're simply not as productive as they are. And oftentimes there is some insurance that covers those type of business losses. And in this case, the farmers would want to pursue the manufacturer of the defective milk product, or their insurer in that case would want to pursue that. And all these three situations on the screen are going to invoke some aspect of the Economic Loss Doctrine. So keep those in mind as we go along, and think about how as what we're discussing might affect those cases. What is the Economic Loss Doctrine? Well, pretty straightforward. Basically, it's this court-made rule that basically bars purchasers from recovering solely economic losses from manufacturers under a tort theory. And I think that everyone's pretty familiar with that tort theory. It's what most of our complaints look like. There's someone was negligent, and that's a tort theory as opposed to a contract theory. But basically, what the economic loss doctrine also does is it prohibits a recovery in tort, so on our negligence theory, for a product defect that causes damage only to the product itself. And I'll explain what that limitation means shortly. If you don't want to call it the economic loss doctrine, and you want to maybe a better way of remembering what it is, essentially it's been called also been called kind of the independent duty rule. And the key here is to focus on the source of the duty. What we talk about is if there's a contract out there for a purchase of a good, for a purchase of a service, that's where the duty arises out of. And so if there is a duty outside of the contract, the economic loss doctrine won't apply. And so that's kind of how it's generally been referred to. But economic losses, what exactly is this economic loss that we're talking about? And economic losses are actually pretty easy when you think about them. Basically, it's what we'll be looking at in our subrogation cases would be, repair replacement costs, rental costs associated with some type of a substitute, loss of use, lost profits. You might have a policy that's paid business interruption losses, and those would be similar, loss of use, loss of profits. But basically what we're dealing with is someone is dissatisfied with the way that a product or a service worked. And they perceive that they received diminished value or inadequate value for the product, and now they either want their money back for the product or money back for a replacement. And that's what we're talking about. We're not talking about personal injuries or damage to other property. So if there's a personal injury involved, you don't even need to think. Economic loss doctrine doesn't come into play at all. And then there's also an exception for other property, which we will talk about in depth in latter parts of this presentation. But basically what we're talking about are these economic loss damages that I know that you guys are probably coming across in a lot of cases. And then the other key concept in the basics of the economic loss doctrine is really understanding the difference between tort law and contract law. Tort law, like I said before, involves those negligence claims. Someone had a duty to you, and they breached that duty of care. For example, when just very easily, when someone rear-ends you, they had a duty of care not to be driving too fast, and that's the type of duty we're talking about. There's no contract with that person that rear-ended you, but nevertheless they had a duty outside of any other duty of reasonable care. When there's a contract involved, that really changes everything, because contracts are two parties bargain for agreement, and they can contract around certain duties and give them others, rights and obligations. It's basically, what does the contract specify? And so if we've got a contract, our remedy is going to be to file a breach of contract as opposed to a negligence or a tort claim. So those are the two real separate bodies of law that we've got out there, and they try to address different things, and it's very important to keep them separately when we're talking about the law. There's also a real big difference in damages. What's recoverable on a contract claim versus a tort claim? For tort damages, obviously the plaintiff has really no limitations. The plaintiff can recover all, compensatory damages. Remember, tort claims we're talking about, those personal injury claims or damage to other property. So what we're talking about is all of the past bills associated with whether it's a personal injury claim. It's easy. It's all the past medicals, all the past loss of earning, future earning capacity, and anything else that is consequential. Contract damages are very different, and really, they can be affected by terms in the contract which limit or exclude any right of recovery. But what they aren't is when you've got a contract, you can't claim for punitive damages. Oftentimes, you eliminate any insurance coverage if you have a breach of contract claim as opposed to a tort claim. So there's a lot of distinctions and there's a lot of reasons why we would want to plead a tort claim as opposed to a contract claim. And damages is probably one of the biggest things, is that we can usually recover more under our tort theory than we can under our contract theory. But let's go back in time a little bit here and talk about what happened to bring about this economic loss doctrine legal precedent. And I think everything really goes back to about 1965. So I put up, the photos of the '65 Mustang up there. We got the Rolling Stones. We got the Civil Rights Movement. Back in 1965 is where I'm taking you. And the first big decision was the Santor decision out of New Jersey. This was a case involving defective carpeting. We had a consumer who bought grade #1 carpeting. Unfortunately, when he got it home, got it installed, he had some problems with it immediately. There were lines in it. The carpet was bunching up. Basically, it was a crappy carpet, crappy install. And so the purchaser, what he did was he tried to have it replaced by the retailer or the manufacturer, and none of them would replace it. So he was forced to sue them. And he sued the manufacturer and the distributor in strict products liability, saying, I have a defective product. There is a product liability theory. All I have to do is show the product is defective and that you produced it and I can recover. Now, product liability goes back to this. It's a tort claim. Remember our distinction between tort and contract. So he did not bring any contract claims. He didn't say that there was a warranty out there that said it was going to be a good carpet, or that I had a straight breach of contract. What he did was say, I have a tort claim for product liability. And keep in mind, the defendants that he sued, the manufacturer and the distributor, were defendants weren't the defendants he bought the carpeting from. He bought the carpeting from the retailer. So he was suing these people against whom he did not have a contract. And obviously, the manufacturer and the distributor said, "Hey, you can't sue me for your defective carpet because we don't have a contract." And the only reason he's suing them is in tort. And so they said, "Well, how can you sue us in tort when there's no personal injury or damage to anything other than the carpet?" Well, the New Jersey Supreme Court was the first court that really got into this, and they just didn't buy the defendant's argument. And they said that contractual privity, the fact that there was no contract between these parties, simply wasn't required in products liability cases. If you think about it, when someone who's injured in some type of or when you think about it, when you've got a case where you've got a fire, defective product causes a fire, we can sue the product manufacturer, right? Well, that's what the New Jersey Supreme Court said. Basically, there's no difference. I don't need a contract to be able to sue on a products liability case. So the court said all we're doing is merely extending strict liability, products liability, into damage where there's only damage to the product itself. So that was the first key decision, and basically that decision said we can sue in contract or we can sue in tort. It does not matter. The second decision was all the way across the country, still in 1965, and it was out in California. It was Seeley versus White Motor Company, and this was something probably, we've seen probably more than the defective carpet cases. It's an auto case where a small business owner who needed a truck for his business bought this defective truck. Basically, the truck was a lemon. It was taken in numerous times to be repaired. Finally, 11 months in, the brakes failed while the gentleman was driving on the road. He was unable to stop. The vehicle flipped over, went off the road. Fortunately, he was not injured, but the truck was basically a total loss. So we don't have any other. We don't have a personal injury, and we don't have any other property damage other than the vehicle itself. The owner nevertheless sued the dealer and the manufacturer to recover the damage to his truck and his lost business income. Because remember, he bought this for a business, and so obviously when it's not in service, he can't use it, he loses income. So those were the two components of his damages. And he cited to this Santor case out in New Jersey and said, I can sue in products liability or contract, and so I'm going to sue in both. I'm going to sue both under a warranty, which is a contract claim, and under strict product liability. The court, unfortunately, at that point in California was probably a little bit more conservative than California is today. And they were not buying the New Jersey Supreme Court decision. They basically, came out and said, look, you can pursue a contract claim against the dealership where you bought it. And under that contract claim, you can recover the purchase price of the vehicle and potentially some lost profits. But they completely rejected the idea that he could pursue a product liability claim in tort where there was no damage to other property or personal injuries other than just to the vehicle itself. The court emphasized the fact that there's this whole body of law out there. The Uniform Commercial Code is out there that deals with sales, that deals with transactions, the sale of goods. And if we allowed parties to circumvent the UCC by just filing tort claims, there really would be no need for contracts, because we could always just file a tort claim if we were dissatisfied with how the product that we bought was operating. And then, so we've got these two competing decisions in 1965 out there. And there's no, so there's a big battle line, there's a big black and white. How will different states treat this? As time went on, most states went out and adopted the Seeley approach, but there was a handful of courts out there in states that adopted the Santor approach. So we had this big divide, as you call it. And what we needed was the Supreme Court to step in and tell the entire country what the law was. And so now you've got this East River decision in 1986, and as you can see, we've got Tom Cruise up there, we've got Max Headroom, I think his name is, and we've got the 1986 Mustang. As you can see, there's a big fall off in appearance there. I would much rather have the 1965 Mustang than this crummy 1986 Mustang. Nevertheless, onto the East River case, the Supreme Court finally steps in and has to deal with this whole issue of can a purchaser sue for damage only to the product in tort and in contract, or only in contract? What was going on in East River was basically the case involved 4 oil supertankers. So these are these big ships that you see out in the ocean hauling oil back from the Middle East. So I mean, they're just huge. They're really massive. And what happened once in service, once these were out on the ocean, each of the 4 supertankers' turbines, they had these big turbines that turned the engine, failed, and they put the whole ships, all the ships, out of service. You can imagine the lost business interruption loss that was available when you had to take 4 oil tankers out of service, and you also had to repair and replace the defective products. So what the ship owner did was he sued the manufacturer of the turbines for his business losses and the replacement of those turbines. He sued in strict product liability. So the question for the Supreme Court was, can I pursue as a ship owner my tort claim, not my contract claim, my tort claim against the manufacturer of these turbines? And the Supreme Court basically settled the issue by choosing the Sealy, the California decision, as opposed to Santor, the New Jersey decision. The Supreme Court apparently, if you read through the decision, they're fairly concerned with opening these perceived floodgates to all kinds of tort claims for all kinds of unspecified amounts of damages if they agreed with the Santor approach. Because when you think about it, if I sell a wind turbine, if I sell one of these turbines to a small ship owner who's just using it for his own pleasure, or if I sell a turbine to a business owner, all of a sudden I have all these huge potential business interruption claims from the ship owner who's using it as an oil tanker, as opposed to the ship owner who's using it for pleasure. So you've got this wide divergence and unpredictability of what the damages will be. And the Supreme Court basically wrote that products liability law grew out of a public policy judgment that people need more protection from dangerous products that is afforded by the law of warranty. However, it is clear that if this development were allowed to progress too far, contract law, this is the famous quote from this decision, contract law would essentially drown in a sea of tort law. And so you can see their concern was we don't want to open the floodgates up to all these potential unpredictable claims, and so we're going to stick to the UCC, the Commercial Code. We're going to stick to the contract and allow people to bargain for their duty in the contract and not allow some common law tort theory to come in play. And so the Supreme Court decided it all and made it even more confusing for us attorneys out there with its decision in East River. So that's where this whole economic loss divide kind of grew out of. Some of the policy justifications, just so you understand them, obviously as a court, it was concerned with keeping the two bodies of law, tort and contract, that we talked about separate. It wanted to protect parties' ability to contract, allocate the risk in a written contract as opposed to some independent negligence duty that might be out there. It was concerned about basically it was concerned about inhibiting commercial activity if it allowed the floodgates of these speculative damages. Also, number 5, by opening up huge potential for damages. And so basically it wanted to encourage the parties to assume, allocate, and insure the risk of a defective product within their own contract. So now we've got the current state of the law. There are basically 3 approaches, and if you get a chance to, after this seminar, go to our website. I know you're familiar with it. We have a chart and basically a brief memo that explains the economic loss doctrine in all 50 states. It goes through the minority rule, the majority rule, and the intermediate rule, and and basically breaks down by state which ones follow each rule. The minority rule is the Santor approach, that New Jersey case. There's only a couple states that even remotely follow this approach, and it's really only one or two. And they completely reject the economic loss doctrine and allow their plaintiffs to sue in both tort and contract. So if you're in one of those states, which is reflected on the chart, you'll want to know that there's no restrictions on your claim, that you can file in tort and contract. You're just going to have a much easier time to recover in those states where you've got a defective product. The majority rule, however, is the East River Supreme Court decision, the Seeley decision in California. Those have become the majority rule, and basically that is basically a strict bar that you cannot bring a tort claim for purely economic losses related to, like I said, only damage to the defective product. But obviously that's a really harsh rule, and to kind of mitigate some of the unintended consequences of such a harsh rule, there's been a lot of states who have adopted what we'll talk about throughout the presentation kind of as the intermediate rule. The intermediate rule is basically similar to the majority rule, but with a bunch of exceptions. And we'll talk about those exceptions because that's really what you need to know. I mean, you can find out if you're in a minority state or if you're in a majority state, and you can predict what's going to happen to your case, whether you've got a claim. But what we really need to focus on for purposes of this seminar is really the intermediate rule. On those states where there are exceptions, how do we fit our subrogation claims into these exceptions? How do we get around the economic loss doctrine? And that's really the purpose of this presentation. Before I get into the exceptions, are there any questions out there that you know already that I've already started some confusion, or should I just move on? You guys good?
Good.
Good. Well, let's talk about the exceptions to the economic loss doctrine that are found in this intermediate rule. We're looking for the loopholes. We are the criminal defense attorneys looking to get our clients off here. You can look at it that way. First one that we need to talk about is this concept of privity. What do I mean when I talk about privity? Basically, I think the concept goes hand in hand really with the idea of a contract. In contract law, we need two parties to an agreement. Those two parties basically are what's called in privity of contract, meaning that they have agreed to boil their transaction down into a written document, sometimes an oral agreement, but usually it's a written contract. This type of concept just doesn't exist in tort. So this is really a contract concept. Like I said, when someone rear-ends you, you didn't have a contract with them. You've got a tort claim against them because they were negligent. But in contract, you don't need to have a contract with that person to sue them in tort. But when we've got a contract, we cannot go to tort. So we are stuck with this concept of tort of contract. Anyhow, important for us pursuing subrogation. The subrogated insurer, down at the bottom, the subrogated insurer has this privity concept if its insured is in privity with the defendant. So if basically we're stepping into the shoes, and if our insured has that privity, we will have that privity as well. So there's no worries that as an insurer we're somehow a third party to the contract. Some courts out there will apply a lack of privity exception, meaning that I can sue in tort if I don't have a contract with the person. And here's what this comes up every day in the construction practice. So often we will have a homeowner who is contracted with a builder to build a home, or has contracted with a general contractor to redo their home in some capacity or provide some improvements. And so often that contractor, that builder, will then subcontract out the work. The only parties that are in privity are the homeowner and the general contractor or the builder. There is no privity with that subcontractor, okay? So if the subcontractor is the one who goes in and provides the crummy work, installs defective windows that leak and, damage, the home, or installs these, whatever defective product is that is installed by the subcontractor, it's really the subcontractor that's at fault. So we run into a problem if we are representing as a subrogated party the homeowner trying to pursue a claim against the subcontractor where we don't have a contract with them. Some courts, it's a minority, but some courts will allow us, and this North Carolina decision is an example, where we can pursue those subcontractors on a negligence theory despite the fact that we don't have a contract with them. Because basically the courts are concerned that we would be left with no remedy to pursue these, I guess you would call them remote purchasers or these remote subcontractors since we don't have a contract with them, we can't pursue a contract theory. And if we didn't have a tort theory available because of the economic loss doctrine, we would have no remedy. So there is this concept of a lack of privity exception that is established in a handful of states. Next, and most importantly, is the other property exception. This is the one that we want to focus on because this is the easiest way to get around the economic loss, we'll call it the ELD, so I don't have to keep stumbling over it. Anyhow, the other property exception is pretty straightforward. Damage to property that is the subject of the contract is an economic loss, right? While damage to secondary property is not an economic loss. Other property is the secondary property. And here's my example. It's basically the Toyota Prius. You've got a Toyota Prius. You park it in the driveway. It's got a problem. It overheats. It starts a fire. The Toyota Prius is destroyed in your driveway. In that scenario, the economic loss doctrine would bar any tort claims against Toyota for having a defective product. Basically, what you're saying is you're strictly liable Toyota in tort because the car burned up and now I need to replace it. The second example is where the other property exception comes in. This is when the Prius is parked in the garage and catches fire, and the home catches on fire and destroys the home. And so now you're a subrogated party. You've got a claim not just for the auto, but you've got a claim because you had to repair or replace the home. The home becomes secondary property, and therefore the economic loss doctrine does not apply. So that's really one of the most clear examples I can give of the other property exception is this straightforward vehicle fire case, which I know that if you guys get I know you guys do the auto business, so you're going to get a lot of these cases. It becomes more difficult when we start dealing with component parts or larger losses outside the automotive industry, and the lines of what is other property versus what is what is the property that we're talking about in the contract becomes very blurred. One example, and I'll give contrasting examples here. The first one is this ice fern shipping case, and it involved basically a governor, which is a component part in an engine. And the ship owner had this governor repaired or removed and serviced, and then reinstalled back into the engine. The governor failed while it was out in the middle of the ocean, causing significant damage to the entire engine. Okay, so it's not just the governor itself, but the governor failed, and then the entire engine was damaged. So what they had to do was when they took it back to, back into harbor, they had to have the entire engine serviced and repaired. And so they sued in tort the manufacturer of the governor and the party that serviced the governor, seeking all of those damage. The ones we're talking about, the lost profits, the repair and replacement cost, nuisance, the cost of having to have this, and my employees out of work as well. So all of those economic damages were brought into the context of a tort theory through a negligence claim. And the court said, the defendant obviously raised the economic loss doctrine as an issue, saying, no, you're suing us for economic losses related only to the damage to the governor. But the court said no, because only the governor was covered under the contract. The failure of the governor caused damage to the vessel's engines, and since we're talking, basically what we're saying is because the vessel's engine was other property with respect to the governor. So you can sue under a negligence theory where the defective component causes damage to the whole. Okay? I know that can be kind of a difficult concept about what is a component versus what is the whole, especially when we look at the second case, which is out of Wisconsin. And it involves essentially, I guess you could look at it to be a very similar factual scenario, because what we had here was a sprinkler system manufactured and installed, manufactured by Viking, accidentally went off at a bank building and caused, obviously you can imagine, a lot of flooding and water damage to the building. St. Paul, subrogated insurer, stepped in and pursued a negligence claim, a product liability claim against Viking Corporation for basically designing a defective sprinkler system. Now Viking again turned around and said, just like the defendant did in the prior example, no, you're suing us for all these economic losses because our product malfunctioned, but no, our product was merely a small component in an integrated or a system. The entire product, basically, they made the argument that the bank building itself was the entire product, not just this small component, the sprinkler system in the bank building. The facts were rather straightforward. I mean, the bank contracted with a general contractor a while back for the construction of a new bank building, which included a sprinkler system. So this is original equipment to the building, not something that was put in later, which would make a difference. And the court said because the product was the building itself, and the failure of the sprinkler system resulting in damage to the building constituted a failed economic expectation. Basically saying the bank building didn't live up to my expectations because the sprinkler system in the bank building was defective. So this is a real important distinction, these two cases. What is a component? What is the product? Are they integrated? Or are we able to tell the court that no, the component part is separate from the integrated system? In Florida, obviously, I think we'll be able to pursue those type of cases. But in Wisconsin, if you look at this decision, they're going to take this overall broad view that the product is not just a single component part, but it's the overall product. It's the bank building in this case. So that's a really big, important difference, and will obviously completely change what our subrogation potential is just based upon what jurisdiction we're going to be in. I think the result of the Wisconsin case would have turned out differently had the sprinkler system been installed after the original construction of the building, or had they been pursuing a servicer of the sprinkler system that serviced it recently, but because they were pursuing the original manufacturer of a component part, the court said the economic loss doctrine applied. So we've covered other property, and now we want to move on to the second real big exception that is out there. And this one, I guess it kind of makes sense when you think about what the different policies are. What tort policy tries to protect, which is individuals from being hurt or their property from being damaged, versus what contract law tries to protect, which is the expectation and the bargain of the parties. That is this sudden calamitous event or this dangerous condition exception. And it's pretty interesting, and I think that when we're dealing with some of our large losses, there's a potential for this exception, depending upon the jurisdiction, to come into play. Basically what this exception says is courts are going to differentiate between plaintiffs who are merely disappointed with the expectations or disappointed with how the product performed, and those who are actually endangered by it. And if you're endangered meaning not injured but in the zone of danger, if you're endangered by it, we will allow you to pursue a tort claim, even though only the product itself was injured. Here's a couple examples. Maryland is one that basically allows us to pursue this theory. It often comes up in this fire retardant wood that companies will sell and basically tell consumers, hey, buy the fire retardant wood and your home will probably not start on fire. Well, what happens when it does catch on fire and the fire retardant wood didn't live up to its billing? Well, in these instances, for that type of product, the court said, I think there's a lot of danger there in fire retardant, in this fire retardant wood, because of the representations that are being made that it won't catch on fire, that your house won't burn, basically because it involves this event, this very dangerous event, which is your home catching on fire. And so courts have narrowly tailored an exception for the fire retardant wood. So you could sue the product manufacturer in tort for providing a defective product component in your home, even though there's not necessarily damage to other property. The other one is an exception that a Georgia court created for a defective drilling machine that suddenly ignited. Obviously, the drilling machine was being used for work-related purposes in a business, and the fact that it was prone to ignite put a lot of workers in jeopardy, and a lot of, even though they weren't injured, they were able to get out of the area when this thing exploded. The court said the fact that it's being manufactured and sold for this specific use and is designed to be around workers who will be using it, we're going to create an exception here and allow you to sue in tort. Really the rationale is this is a dangerous product. If we allow endangered users to sue in tort, that will provide incentive for the company to basically design a better product that will not endanger users. Again, that's back to the fundamental purposes and policies behind tort law. But this exception doesn't work all the time. New Jersey, this is probably more the majority approach, is to basically reject this exception. In New Jersey, basically what we had was a crane collapse, and the crane only damaged itself. Despite this photo, which is not from this case, it looks like there might be damage to the other construction. In this case, what happened was the crane just collapsed. The crane became a total loss, and the company who owned it sued the crane company because basically just for the recover of the purchase price replacement cost of the crane. And they argued, hey, the economic loss doctrine doesn't apply here because crane collapses are a very dangerous thing. Our workers were in the area. They could have been injured, but were not. Other property was in the area that could have been damaged, but was not. Unfortunately, the majority approach, which is embodied in this decision, will not carve out that exception. It's very limited to certain states and certain types of products. Another product that kind of falls into this exception and that the majority of states do follow is this asbestos exception. So when asbestos is found in a building, it has to be removed and replaced at a very high cost. Whoops. You guys still with me?
Yeah.
Okay, good. I just heard some feedback. I didn't know. Anyhow, so when the insurer has to pay its insured the cost of having asbestos abated, they will allow a subrogated claim to pursue those costs against the manufacturer of the asbestos. So there's a special exception for asbestos because obviously asbestos is just extremely dangerous, cancer-causing. Anyone who comes across asbestos in its airborne state, could potentially, contract lung cancer, various other forms of cancer. So courts have found asbestos to be a very special exception. And I think we could take that, and I think that in certain cases we might be able to use that with other types of hazardous materials as well if they're involved in cleaning up a loss or involved in some claim that's been paid to get around this economic loss doctrine. Here's another exception that we'd want to look at very carefully in our subrogation cases is whether we can plead fraud, or maybe not fraud because there might not be insurance coverage for that, but negligent misrepresentation is a pretty popular theory. And where we can establish, obviously courts say where you can establish that the contract was entered into fraudulently, we're not going to hold you to it. And we're not going to apply the economic loss doctrine because the policies are completely undermined if someone fraudulently induces you into that contract. Negligent misrepresentation is a little bit lower of a standard, and so not all courts will extend this exception, but some have, and some have applied it even to parties who were not in privity. It comes up often in maybe construction cases where someone has made some type of misrepresentation as to the quality of work or their abilities, and that basically induced us or our party into contracting with them. And courts will, again, like with the fraud exception, they'll say the policy of an equally bargained for contract is not here. So I'm not going to apply the economic loss doctrine. I will let you sue in tort where you can prove a negligent misrepresentation. And that kind of dovetails into consumer transactions. Because you bring up the undermining of the contract. Well, what about these situations where we have consumers who, the average Joe is not necessarily as sophisticated as a large construction company or, a large insurance company. So maybe we shouldn't hold those consumers strictly to these contractual requirements and to the economic loss doctrine. Because, they don't have lawyers drafting the contracts. They don't really understand the terms. They don't understand why they wouldn't be able to pursue a claim against the manufacturer of a defective product. You know, I mean, if your Toyota Prius burns up in the driveway and your dealer's out of business, I should be able to sue Toyota to get me a new car because that was a piece of garbage, right? That's what the average consumer kind of thinks. Well, courts have fundamentally rejected that argument, and basically said the relative bargaining power or position is not relevant to the economic loss doctrine. So don't think that that is going to be an exception to get us out of that. You know, basically, it goes back to that policy that courts want to enforce, is that the purchaser, whether it's a consumer or a commercial party, is really in the best position to allocate the potential risk that the product isn't what they thought they were getting. And how do we do that? Example, purchase an insurance policy for your automobile that would cover the loss. And I think that's pretty commonplace. Even Joe Schmo consumer can figure out he should buy an auto policy that covers his car. So courts are going to reject that argument. Next, now this was a more recently debated area of law, and that is service contracts. Now we're not talking about the purchase of a product, or you know, we're not talking about the going down to the auto dealer and buying the Prius. We're not talking about buying a defective heater or something like that. What we're talking about is a service contract. So a couple examples I thought of was obviously moving companies. That was from my original example at the beginning. Moving companies. They were trying to. They had the printing company had hired the moving company to move that big press. Another one is an alarm company. You'll get this really often. Is these fly-by-night or even well-established alarm companies will say, I will monitor your fire alarms. I will monitor your security alarms. Well, what happens? They're not monitoring. They don't pay attention. The alarm sounds. They don't call the authorities, and the business burns down, or the business is robbed, even though they were supposed to be monitoring. Well, that's a service contract. You've agreed by contract with them to have them monitor your company. And so the question is, do I get to sue because their employee who was supposed to be monitoring the alarm was negligent, or am I stuck with what's in my contract? And the courts are basically pretty divided on this issue. So this is one that goes state by state. You know, I've got the Illinois decision, and then I've got the Wisconsin decision. Illinois, basically, it's a small majority, but Illinois is in the majority that says the economic loss doctrine applies equally to service contracts as it does to the purchase of goods. So basically, I won't be able to sue that alarm company in tort, even though their employee was negligent. However, Wisconsin, which is in the minority, issued this decision in 2004 that said service contracts simply don't fall under, and I think this was a really good decision. Basically, they've accepted service contracts from the economic loss doctrine. Even though you've got a contract for services, just like your contract for the purchase of an item, purchase of a goods, we're not going to hold you to that only contractual remedies, basically because there really is no equivalent. You don't have the same remedies that you do for purchasing a defective product as you do for purchasing a defective service. The Uniform Commercial Code doesn't apply to service contracts, so we really can't look there for remedies. So the court is saying, look, we see this as being a void where the consumer of a service contract will have really no remedies when there's negligence involved that cause damage to, or basically damaged economic losses. And what happened let me explain what happened in the Cease Electric case out of Wisconsin, so you have a better picture of what I'm talking about. Because you want to see how does a service product damage, how to provide economic losses. Well, what happened in Cease was we had a big agricultural operation, and one of the things that they had on this was a very large, basically, I don't know, a chicken factory, I guess you'd call it, where it's a huge barn building with thousands and thousands of chickens. And what they had hired Cease Electric to do was come in and fix and install a new ventilation system for the chicken building. And Cease came in, they did some rewiring, they left, the ventilation system failed, all of the chickens in this huge building, thousands of them died. And so basically the company, the chicken company, filed suit. I think it's a subrogation case here. If you can see, it's insurance company in North America. So they're pursuing, standing in the shoes of the chicken company, and they pursued the electrical contractor who came in not only for having to repair and replace the defective work that they did, but for the cost to basically all those business losses that they took when all their chickens died. So this is pretty remarkable. I mean, it does run right against this trying to limit liability for unforeseeable damages, because you can have this little local electrical outfit who's in one case trying to rewire the bathroom at my house, and then the next basically doing a similar job at a larger chicken barn building, and all of a sudden they're in it for several millions of dollars because they wired something wrong, leading to this calamitous loss of all of these chickens. Now, Wisconsin's basically said, well, what other remedy do you have? And so they've allowed the tort claim and said the economic loss doctrine doesn't apply. But that is very significant, and we'll want to know state by state when we've got a contract with some electrician or a plumbing contractor, whether we can pursue them for those type of economic losses. I guess this kind of dovetails as well into that last slide, is what happens when we've got something that's not quite a service but not quite a product, or a little bit of both. And this kind of comes up in the construction cases, as you'll see. If we purchase, if you go out there as a homeowner and purchase a new home, what is the product? Is it the home, or is it not? If there was a defective plumbing job done to the new home, can I sue the plumber, or am I left with my only remedies being my home warranty? Well, courts generally come down on the line of saying, if you're purchasing a new home or new construction, the product is the home itself. So the economic loss doctrine will apply. You won't be able to sue any of the subcontractors who worked on the different component parts of your home. Your only remedy, again, because the economic loss doctrine applies, would be a warranty claim against the builder. Cross your fingers, assuming they're still in business. Whereas if you're doing a renovation project where you've hired a contractor to come in and put like new siding, new stone siding on your house, well, can I pursue them? Is this a product? Am I buying a product from them? Am I buying the stone sheeting that they're putting on my house? Or is this a service contract, which my state says is accepted? In these renovation projects, I think the majority approach is going to be that it's a service contract and the economic loss doctrine won't apply. That's a very important distinction, because you're always going to get the defense that, hey, you're buying a product, economic loss doctrine applies. Well, no, I say I bought a service. You agreed to install this product. And so that's where you get this mixed, and the courts are going to basically look to the totality of the circumstances. You might have to do a lot of discovery to figure that out, whether it's truly a service or truly a product case. Of course, we don't want to leave our homeowners or our subrogated insurers without any remedy in those new construction cases. So what we've got to look for, and often if can be easily overlooked, is some statutory. So now we're outside of tort, we're outside of contract, and states, a lot of them have recognized that these consumers are going to be left without any remedy because of the economic loss doctrine. So they've set up state consumer protection laws that will allow homeowners or the subrogated insurer, if allowed, to step into those shoes and pursue a claim against the contractor, the general contractor, by making them statutorily liable for any defects in that new construction. So we've got to look, and I've given you an example of Nevada. That's just one example. A lot of states have these consumer protection statutes that apply. So don't just think tort or contract. Sometimes there's a statutory cause of action, and you'll want to make sure that your attorney, whether it's us or someone else, is looking at all of these options. Is there a statute that applies that'll get us around the economic loss doctrine? Finally, we're almost to the end here. We're catching the last few slides. Another exception that you're going to see is professional contracts. So we might be in the construction field again, where we've got a construction loss. We always want to look at the engineers and architects, because generally speaking, again, this goes back to that independent duty rule that I talked about earlier. So we're talking about, ooh, there it is. See that? Wow, that's a neat trick. Independent duty rule. These professionals, whether it's an attorney, an engineer, architect, or some environmental consultant who comes in, they might have a contract, but the law says that they have an independent duty that exceeds the contract, that they have, a duty to act with reasonable professional conduct. And if they fail in that, not only could they be liable as professionals under the contract, but they will be liable in tort. So the economic loss doctrine will not apply to these professionals. So that's why when we've got these construction cases, we want to look at, see if there's any way we can make the engineers or the architects liable. Did they provide faulty drawings that made the construction basically flawed from the beginning? And I'll get you a little checklist at the end here on what we should be looking for. Okay, these are the things that you want to look for. We've gone through the exceptions. We've gone through the majority and the minority and the intermediate approaches. But what should I be looking for, especially when I know I'm in an intermediate state approach where there's going to be exceptions? First, always, was there damage to other property? Because if there was, if part of our subrogated claim involves not just damage to the product, but damage to something the homeowner owned, something the business owned that was separate, we're going to be outside the economic loss doctrine, so we can pursue those claims. But if we're not, if we're just talking about damage to the product itself, and we're stuck in one of those states, we can try to argue that this was an inherently dangerous condition or product, and that's very subjective. A lot of times that will allow us, at least, because our goal is to bring dollars in. Even if we've got a claim that might result in a court decision that goes against us, we've got an argument if we can make, if it's a crane collapse, I can make the argument. I don't need to go to the district court and prove I'm right. As long as I can get in there, get some kind of an offer from the defendant, that makes everyone happy because we can bring some money in, at least can we make the argument? You know, I hate to have the defeatist attitude that, well, you know, we're in an ELD state, and you know, Paul, I just don't want to pursue that claim because I'm pretty sure we'll lose. Well, can we make an argument? Can we at least make this argument and try to see if we can't bring some dollars in? And that's where we need to look at. Third, again, was this a commercial or a consumer purchase? If it's a consumer purchase, now the courts, like I talked about, aren't going to forgive them and not apply the economic loss doctrine just because they're a consumer, but that's a red flag that maybe there's a statute out there. Maybe there's a state statute that we can look at. Again, did the contract involve services? If it did, you know, 5 or 6 times, you know, 5 times out of 10, we might be outside the economic loss doctrine, depending upon what state we're in. Is there a professional liability claim? And was there some way we could prove a fraud or a misrepresentation? Those are all things we want to check off if we know we're in economic loss doctrine territory. Have we covered all of these bases? And because those are the ways that we can get exceptions in. So, like I just kind of inferring that, you know, a lot of this stuff is going to be highly case by case. And, you know, as an attorney or as a subrogation professional, you know, there's things we want to look out for. Obviously, the consumer type statutes are easy to miss sometimes because we're not thinking as an insurance company that those would apply. But if we're stepping into the shoes of a consumer, we can usually utilize those statutes as well. But the economic loss doctrine, you know, we can file suit and we can get an answer, and it might not have any affirmative defenses that say, hey, economic loss doctrine. Well, that doesn't mean we're out from under it, because the economic loss doctrine is typically resolved on motions to dismiss or motions for summary judgment, and it's not an affirmative defense that needs to be pled. So just because we necessarily don't see it in the answer doesn't mean it won't be an issue down the road for us. But again, it's highly case by case. So we could have a case where there needs to be lots and lots of discovery to determine whether the product was inherently dangerous or whether there was some fraud or misrepresentation that was outside of the contract that would get us around it. Additionally, in these component cases where we're saying the damage was to other property, remember the bank building or that ice fern shipping case down in Florida, those cases, highly case by case. We're going to need to do lots of discovery to determine whether this was a component part of the product, whether, you know, what was the product itself, the entire building. Those are things that are going to be subject to a lot of discovery. It could drag the case on for a long time, but it also has, again, like I talked about, it has some settlement value, even if we're pretty certain that we would lose on the economic loss doctrine. If I had to see into the future, some of the things that I think that are going to be coming up, and it depends upon on what lines of insurance your insurance company writes, what claims, you know, we're seeing. But obviously, electronic data losses are on the forefront. You know, if a business loses data because of a defective software that's installed, or because the IT firm that they use screwed up, those claims are going to be out there, and there's going to be insurance that covers those losses. And the question is whether we can go after the liable parties, whether it's the software manufacturer or the IT firm. Those are questions that are out there that you might be seeing. Another one that's pretty popular is identity theft. Often you'll get losses. A credit card company or a bank will see losses because one of their customers or a number of their customers had their data hacked because of a retailer you know, allowed hackers to come into their server and access all this personal information. And so that stuff that there is insurance for out there, that insurance companies are paying off. So as subrogation claims, we may see those. And then the question is, well, can we pursue the retailer who allowed the data to be hacked? Should they have taken more precaution? Clearly, we can make a negligence claim, but will the economic loss doctrine bar it? So that's out there. I think the climate change is going to be out there because people are going to be making economic loss claims for lost business income against companies for polluting or anything like that. We might not see that as subrogation professionals, but it depends. There are high-value policies out there that cover different types of losses. That's it. That's my rundown of the economic loss doctrine. I tried to cover most of the exceptions that are out there that you're going to need to know about. So if you've got any questions, let's try to discuss them now.
I'm not seeing any questions. I have a question though, and it doesn't really. These are all our property subrogation specialists here, but I actually have a question, auto-related, if you will.
Sure.
And that has to do with the Toyota recall of the gas pedals.
Yes.
We've got clients that are asking us all about this, and can we collect our money on this? And we've got 40, 50,000 claims that they want us to look at for Toyotas that have happened in the last 3 or 4 years. How does the economic loss doctrine apply to that situation, and what are the ways that we can get around that? The economic loss doctrine for those types of claims?
Well, I think that what you want to try to first look to is simply by making, an implied warranty or an express warranty claim. You don't have to worry about necessarily those claims if they will honor those warranty claims. Now, if they won't, and you've got to bring a tort claim, I think it's pretty clear that tort claim is going to be subject to the economic loss doctrine, because we can't say that they negligently designed the vehicles because there was no damage to other property or there was no personal injury, because you're just looking for the repair cost or replacement cost of the defective brakes. So the economic loss doctrine would apply, but I would anticipate Toyota at this point would probably consider honoring a number of those claims, especially if they're more recent.
Yeah, what about the damage to the vehicle? What about the damages the vehicle caused, the injuries the vehicle caused? What about an inherently dangerous product that we get around the economic loss doctrine because Toyota realized somewhere along the line they've got a dangerous product here, and they finally made the recall, but they didn't man up until.
That's great thinking. If there is damage to other property, obviously you can pursue that. If there's damage that was resulted from a personal injury claim because someone was hurt, those subrogation claims can be pursued. Absolutely, those are not barred by the economic loss doctrine. And if we're in a state that allows the exception based on a dangerous product or a sudden calamitous event, we could bring that. And you should do that. You can even make that argument in states that haven't really said one way or the other. That's certainly a recognized exception to the economic loss doctrine.
What were we talking about, Adam, of the dangerous, and he may have touched on that, but yeah, a product that's just inherently dangerous, and you just did touch on that you get around that, the economic loss doctrine about that.
Yeah, it's gonna be state by state, but the better you can make the story, if you can place employees, right around the area of, it's designed to be used in the middle of a work floor with lots of employees around. Whatever we can do to make the story better for that type of case, as opposed to, making it sound like it's just this remote product that, if by, one person might have been hurt or might potentially be hurt. But if you can make it look like it's just this disaster waiting to happen, that's the way we want to craft that type of an argument.
Yeah, something else, Adam?
Brakes themselves fail. But let's say the vehicle does hit an object, but it doesn't really cause damage to that object. If there's damage to other parts of the vehicle, is that all considered the one product? Or is it the failed brakes that's the product left for the bumper?
Yeah, that's the classic Sealy case. That's the one where the brakes failed, the car rolled over into the ditch. It caused damage only to the vehicle. The fact that in your scenario that it hit a post or something, some other piece of property, but the other property wasn't damaged, and we're not pursuing a claim for damage to that other property, that would still keep that hypothetical within the economic loss doctrine.
Okay. Any other questions? None? Okay. Well, I think you've answered our questions. It was a great presentation, Ryan. Thank you very much.
Absolutely. And if anyone wants or needs the presentation or has other questions after they think about, feel free to email us. We'll be happy to answer any questions.
Great. Thanks again, Ryan.
Thanks a lot, guys.
Okay. Have a good afternoon.
You too. Bye.
Okay. Yeah. Bye-bye.